Hello everyone and welcome back to the channel. In this video we're going to be talking on SQE2, civil dispute and dispute resolution, and in that we will be talking about the interim application part 2. We will be discussing evidences, drafts, orders, issues, services and further evidences. So let's get on to the video. Now in interim application, it is very important that to understand this procedure after the interim application is made. It is very crucial for this exam. It is not enough simply to complete the application form N244. The court also needs to see evidences, know exactly what order is being requested, ensure the documents are properly served on the other party, and allow both parties an opportunity to respond before the hearing. Not only that, these procedure steps ensure that both parties are treated fairly and the judge has all necessary information to make the correct decision. So let's quickly go through this again. So when you make an interim application through whether it's for the extension of time, or whether you're looking for a junction, or whether you're looking for any sort of order, summary judgment, you fill up the N244 form, which is an application form, and then you will be stating in that form that why do you need the order, what order you seeking for it, why do you need it, legality behind that, supporting evidence. You pay the relevant fee, you file the application in the court along with the evidences, and then you will be serving that application to the other party, which gives an opportunity for the other party to review all the evidences, and if for example they opposing the application, they can respond with their evidences. The best part in these procedural steps ensure that both parties are treated fairly, and most importantly the judge has all the necessary information from both parties to make the correct decision. Next one, the evidence in support of an interim application. That what sort of evidence you can put into it. Whenever a party makes an interim application, they should consider what evidence is needed to persuade the court that the order should be granted. In some situation, under the CPR specifically requires evidence to support an application. For example, certain applications such as those involving injunctions almost always require detailed evidence. So injunction is a serious interim application. For example, what are injunctions? You want someone to do something, or you want someone not to do something. For example, an employer is making a claim against the former employee that they have some sensitive data and they are going to publish it. Now the hearing can be after 6 months. So in order to prevent that, if they wait for the hearing date, then the whole purpose is going to be killed. If the sensitive data will be published online, that will be almost irreversible. So for that case, they can put in an interim injunction application to stop the former employee to publishing the data till the hearing is concluded. In order to make that application, the employer should add this obviously N244 form. They will be seeking an order. What order they're seeking? Injunction. The former employee should not be publishing that data. Why they're seeking it? Because it's sensitive and it's very crucial for the company. Legality behind it, obviously they can put the reasoning behind it. Supporting evidences, it could be a statement, a witness statement, it could be the witness statement, certain evidences they have that the former employee is holding that data, and then obviously they'll be serving the same form as the other ones. So this is one of the example. So in some situations, let's quickly recap that. So in some situations, the CPR specifically requires evidences to support an application. For example, certain applications such as those involving injunctions almost always require detailed evidence, not simply merely a witness statement. Even where the CPR does not strictly require evidence, it's generally good practice to provide it. Judges are far more likely to grant an application when it is supported by clear facts and evidence rather than unsupported assertions. Think of the evidence as answering the judge's question, why should I grant the application? So rather than, remember, before it comes to the hearing, it's going to go, you'll be serving on the other party, and then it will go to the court, and then the court going to decide that should I grant without the hearing or with the hearing. So if you have enough supported evidence, you might come up to an agreement with the other party, and if not, the judge may grant you your application without the hearing, and the far scenario is going to be, they will be heard on the hearing. So the stronger and more credible the evidence is, the more likely the application will succeed. Now, the question is, how can the evidence be given? Evidence supporting an interim application can be provided in 3 different ways. Number 1, evidence with the application notice and Form N244. For straightforward application, the applicant may include the relevant facts directly with the Form N244. This is suitable where the application is simple and the facts are not disputed. Let's quickly go a real life example. A defendant needs an additional 7 days to file a defense because their solicitor has unexpectedly been admitted to hospital. This explanation can simply be included in Form N244 without preparing a lengthy witness statement. Just put an evidence with that which your solicitor will provide with that evidence is they admitted to the hospital. So that's 1 in straightforward application. Number 2, referring to an existing statement of case. Sometimes the information needed is already contained within the existing court documents, such as the particular of claims, defense, counterclaim, or the response. So instead of repeating everything, the applicant refer the court to those existing documents. So in those cases, you don't need further same repeated documentation. So you can just simply refer to the bundle you already submitted it, so you can refer to the bundle, page number, etc., etc. A quick real life example. The claimant applies to amend particulars of claim because further losses have risen during the disclosure documentation. The original particular of claim already explained the background facts, so you don't need to submit that again. The court already have that. So the claimant refers the court to those documentation rather than repeating themselves. Okay, so let's go to number 3, evidence by witness statement. This is the most common method for supporting interim applications. A witness statement sets out the relevant facts, what has happened, why the order is needed, and the supporting documentation. Remember, the witness statement is not always good enough. Sometimes you need to put the facts in the witness statement, that what has happened, why the order is needed, but you also need supporting documentation. Witness statements are especially useful where the facts are detailed or disputed. Let's go through a real life example. A claimant applies for the permission to rely on expert medical evidences. Now, I said in the last video, so the experts normally are to help and assist the court. You cannot rely on the expert advice without the court permission. So for example, if it's a medical negligence case, neither the judge nor the solicitors are doctors. So you need a medical expert. So medical expert will assist the court, but if you want to rely on the expert report, then you need court's permission. So a claimant applies for permission to rely on expert medical evidence. The claimant solicitor prepares a witness statement explaining why expert evidence is necessary, why the issue cannot be resolved without the expert's opinion, and why granting permission would assist the court. So these are the reasoning you can mention in the witness statement. Draft order. You normally, when you file any application, whether it is interim or otherwise, you normally make a draft order. Both parties normally do it to give to the court, and court can simply either grant your draft order when it comes to the final decision, or they can amend it as well, or they can approve as it is. Okay, so draft order. Along with the application, the applicant should usually prepare a draft order. A draft order is simply a document showing the judge exactly what order the applicant wants the court to make. It is not a final order. Final order is going to come through a judge. It is merely a proposed version of the judge's consideration. Providing a draft order helps the judge understanding precise wording of the relief sought and saves the valuable court's time. Example, if the claimant wants an extension of time, draft order might state as the following wording: the claimant shall have permission to file and serve its witness statement by 4 p.m. on the 15th of October 2026. The judge may approve it exactly as drafted or amend it before making the final order. As I said, it's a proposed version. It saves the court's time, and it gives the judge what exactly you are seeking. Now, issuing the application. Once the application has been prepared, the Form N244, the application notice, supporting evidence, and the draft order, these documents are filed at court together with the appropriate court fee. This stage is known as issuing the application. After the application is issued, the court usually allocates a hearing, if one is required, seals the application, and notifies the parties of when and where the application will be heard. At this stage, the application officially becomes a part of the court proceedings. So let's quickly go through again. Issuing the application, it will be the next step. Once the application has been prepared, the Form N244, the application notice, supporting evidences, and the draft order, proposed draft order. These documents are filed at court together with the appropriate court fee of the application. This stage is known as issuing the application. After the application is issued, the court usually allocates the hearing, if one is required, seals the application with its seal, and notifies the parties that when and where the application will be heard. At this stage, the application officially becomes the part of the court proceedings. Now, the very important part, especially for this exam purposes, serving the application. Once the court has issued the application, documents must be served on the respondent. The documents usually served include your application N244, all supporting evidences, and the draft order you are seeking. Although the court has power to serve these documents, in practice, the applicant's solicitors usually carries out this service. Proper service ensures that the respondent knows, the respondent is aware of that what order is being requested, why it is being requested, and what evidence supports it. This allows the respondent a fair opportunity to prepare a response if they are opposing the application. Now, time of service, very tricky and oftenly tested in SQE2. The general rule is that the application should be served as soon as reasonably practicable after it has been issued, and not less than 3 clear days before the hearing, unless the court orders otherwise. So the general rule is that the application should be served as soon as reasonably practicable once it's been issued, and not less than 3 clear days before the hearing. So 3 clear days before means, if you remember the rule of 5 clear days, that the hearing date is the last date, does not count. And now, because you're counting backwards and they are 5 or less days rule, that means the weekends, bank holidays, Christmas Day, New Year's Day does not count. So if the hearing is set on Monday, so Monday is not going to be counted. You're counting backwards. Saturday, Sunday does not going to be counted. So you need 3 clear days. So that's going to be Friday, Thursday, and Wednesday. So that's 3 clear days. 3 clear days before that. This gives the respondent sufficient time to consider the application and prepare any evidence in response. A quick real-life example: a hearing is listed for Friday. To comply with the general rule, the application should usually be served early enough to ensure there are 3 clear days before the service and the hearing, subject to the CPR rules on calculating time, 5 days rule, remember. Respondent's evidence. After receiving the application, the respondent may disagree with it. After receiving the application, the respondent may disagree with it. If so, they may file and serve evidence, usually in the form of a witness statement. The witness statement may explain why the application should be refused, any disputed facts, any documentation supporting their side of the story. The respondent must comply with any timetable set by the court and file the evidence as soon as practicable or possible. Quick example: the claimant applies for an extension of time, claiming that important documents have not been received. The defendant believes that the claimant have delayed unnecessarily and files a witness statement showing the documents were provided weeks earlier. The judge will consider both parties' evidences before deciding the application. Now, applicants reply evidence. Sometimes the respondent raises new facts or allegations in their witness statements. If necessary, the applicant may reply evidence to those addresses to address those new points. Reply evidence should not repeat earlier arguments. Court does not like that, and it does not look professional either. So what you already said it, don't repeat it. However, if the new facts or new allegations comes in the response from the defendant, then you can respond to those ones. Reply evidence should not repeat earlier arguments. Instead, it should deal specifically with the matters raised by the respondent, provided that you have not already addressed them. As with all evidence, it must be filed and served as soon as possible and within any timetable set by the court. So let's quickly go through the example. Respondent claims that the claimant has ignored previous requests for the disclosure. The respondent claims that the claimant has ignored previous requests for the disclosure. Claimant files a short witness statement exhibiting emails providing the disclosure was provided on time. The judge will consider both witness statements before making a decision. Now let's come to the statement of cost. Before the hearing, each party should prepare a statement of cost. So how much they are budgeting for this, what's their budget, and how much they will be spending on this interim application. So both sides will prepare a statement of cost. This is a document that you can download from the government website as well, and you should review it, that what actually goes in there. This document sets out the legal cost incurred in relation to the interim application, for example, solicitor's fee, counsel's fee, court fee, and other reasonable expenses, which we call disbursements. The purpose is to help the judge to decide who should pay the cost of the application after it has been determined. As a general rule, the statements of cost should be filed and exchanged not less than 24 hours before the hearing. Very important. So the statements of the cost should be filed and exchanged not less than 24 hours before the hearing. Failure to do so may affect the court's willingness to consider the cost claim. Normally, general rule is whoever putting the application of the interim application normally pay the cost of both sides. However, court has wider discretions to amend this, especially if one party is behaving unreasonably. Now, putting the whole process together, let's do it all together. Imagine a claimant wishes to amend the particulars of claim after discovering additional financial losses. The claimant completes the N244, prepare a witness statement explaining a newly discovered losses, drafts a proposed order giving permission to amend their particular of claim, means statements of case. These documents are filed at court together with the appropriate fee. The court issues the application and fixes a hearing date. The claimant solicitor then serves the sealed application, witness statements, and draft order along with the evidences on the defendant as soon as practicable and at least no longer than 3 days before the hearing, unless otherwise the court orders differently. The defendant believes the amendment would unfairly delay the proceedings, so they file a witness statement opposing the application. The claimant then files a short reply addressing to the defendant's objections. Again, provided that you have not already addressed them, so do not repeat them. Before the hearing, both parties exchange statements of cost 24 hours before the hearing. At the hearing, judge considers all the evidences and decide whether to grant the application to amend the claim and who should pay the cost of the application. Quickly, SQE2 practical tips. When dealing with the interim applications, always ask yourself, is there enough evidence to support the application? Number one. Number two, which is the best form of evidence? Form N244 itself, and existing statements of case you're referring it to, or a witness statement or other supporting evidence. Has a clear draft order has been prepared? Has the application been made properly issued by the court? Have the application, evidence, and draft order been served promptly and at least 3 clear days before the hearing, unless the court orders otherwise? Has the respondent been given an opportunity to file the evidence? Does the applicant need to file a reply evidence? Has the both party filed and exchanged statements of cost at least 24 hours before the hearing? Following this checklist demonstrates good civil litigation practice even when you come to the practice, and helps ensure compliance with the civil procedural rules. Let me give you a tip for this exam, a memory aid. Think of the sequence as evidence, draft order, issue, serve, respond, reply, cost, statement of cost, exchange 24 hours before hearing. Let's quickly go one by one. So evidence, you always analyze the case before. Always remember, litigation in control. Do not jump to, always court has to be the last resort. So you always analyze the case. Otherwise the client is going to come back to you because you are the one who's advising them. They are a layperson, that you are advising them. So do you have enough evidences to support your interim application? Then you need to prepare the application and witness statements along with that, what order you needed, why you needed, legal basis of the claim, and then you issue the N244 with the appropriate fee. Then you need a draft order, proposed draft order for the court. Then you issue the claim. Then once you get the sealed order from the court, then you serve on the other party as soon as practicable, but not less than 3 clear days before, unless the court says otherwise. Then you will more likely, if they are opposing the application, they will respond. If you want to respond, reply to the response. If there is additional things, then you reply to that, and then 24 hours before the statements of cost is exchanged, filed and exchanged, and then the hearing. This is an easy way to remember the procedural steps leading up to an interim application hearing. Now, an example question. You can pause this video and you can answer the question, which I'll be answering as well. First, I will memorize myself, and then I will read what it says there. A claimant applies for a permission to amend the particular of claim. Particular of claim means statements of case. A defendant opposes the application and files a witness statement explaining why the amendment would cause the delay, what should happen next. Now, the claimant applies for the permission to amend particular of claim. So the first, they have done the right approach. They have approached the other side of the other party to come to an agreement. They did not. So then they should act promptly, fill up N244, that what order they're seeking. So they're saying they're seeking to amend the particulars of claim. So that's the order they're seeking. Why they're seeking it? Because they knew during the disclosures the new things came up and they want to change the particulars of claim. So that's why they need that. And legal basis behind that, obviously they need evidences, that what sort of evidences emerges and why they need to make that order. Then they need to fill up all that along with a witness statement and all evidences, and then they need to file at court. Once they file at court, then they need to pay the appropriate fee. Once it's sealed, then they must serve as soon as practicable, but not lesser than 3 clear days before the hearing on the other side, on the respondents. Once it's been done, then they will get a respond, and if they want to reply to the response, they can do that, and then they need to file and exchange the statements of cost not less than 24 hours before the hearing, and then court will more likely set a hearing. So let's see what the answer says. The claimant may file a reply evidence, usually a witness statement, if necessary to address the new issue raised by the defendant. The reply evidence should focus only on the new matters, be filed and served as soon as possible and in accordance with any timetable set by the court, and both parties should exchange the statements of cost at least 24 hours before the hearing. The judge will then consider all evidences, hear the submissions from both parties, and decide whether to grant an application and who should bear the cost. So that's all for the time being. I'll see you in the next video. Till then, stay safe and thank you for watching.